Let's talk about defenses to the crime of assault in Alabama. I'm going to talk about 9 of them, but that list is not exhaustive. There's more, and they will depend on the facts of your case as well as the creativity of your lawyer. But let's talk about some of the ones that at least come to my mind. One of the most basic ones and one of the most common is self-defense or defense of others. Under Alabama law, you're allowed to use reasonable defense if you're justified in doing so under the circumstances of the case. Now, that doesn't mean that if somebody's punching you, you can pull out a knife and stab them to death. But if somebody's trying to attack you with their fists and you block it and you hit them back, assuming that the circumstances are such that it was reasonable, you would be entitled to a defense. So self-defense, that doesn't apply just to you. If somebody is attacking your girlfriend and you spring to their aid, that could be a reasonable claim of self-defense, and a person could either be acquitted or even prevented from being prosecuted for an assault charge based on that. Another issue that comes up sometimes is identity. There's a bar fight, and it's one of these classic barroom brawls. Billy says, "Hey, Bob hit me." Bob says, "It wasn't me." Well, it would depend on whether or not they can establish it. Let's say that the fellow has a mark on his face and there's a imprint of a ring with, a skull. And there's another guy whose name is Frank Castle who happens to be at the bar at the time and happens to be arrested and happens to have a ring that matches it. Well, maybe they got the wrong man. So identity can be an issue in assault cases, and usually it's when there's some sort of either a brawl, or maybe the person was intoxicated, or maybe they have motive to pin it on somebody else. So that's one of the many defenses. The third would be intent. Let's say that Hank and Frank work on a farm. They're not friends, but Hank is holding a log and Frank is using a hatchet to cut it, and bam, he cuts off his hand. Was it an accident or an assault? Depends on the circumstances. It could be a reckless assault. It depends on the circumstances. It could be a assault first degree where he intentionally did it. But what was going on in the person's mind can have great bearing on whether or not a crime at all was committed or the degree of a crime. And so the state would try to establish that. How do they establish somebody's intent? Well, we don't have windows in our brains. We have no magic way of doing that. So they're going to argue the facts and circumstances as to why a jury should conclude one way or another on an assault case. You also have a right, to some degree, for defense of property in an assault case. So if Bob the burglar breaks into your house and you come around the corner with your trusty baseball bat and kneecap the guy, that's probably a defense to an assault if Bob is claiming, "Oh, I was assaulted." Now, there's a limited right as far as defense of property. If Bob instead is in the driveway and he's stealing your kids' three-wheelers, you probably aren't able to run out there, or you're not able to run out there and shoot him dead. So there's limits on this. It's not an absolute defense, but it can be a defense depending on the circumstances. What I'm saying is it doesn't apply to all circumstances. Another defense is lack of injury or lack of sufficient proof of injury. Assault means that somebody was caused an injury at the hands of another. And what about the injury? For example, if it's a misdemeanor assault and the person comes to court and says, "No, I wasn't hurt," well, then it wasn't an assault case. What about a felony case? Well, again, it depends on the degree of the injury and the manner in which it occurred. For example, there was a case years ago where I was a young lawyer and a fellow got shot through the arm. They went to the hospital and the wound was through and through. They patched him up. He went home. The person who was accused of causing him serious physical injury for assault first degree, and the higher court said, well, it wasn't a life-threatening injury. It didn't leave any kind of permanent disfigurement. It wasn't a serious physical injury under the law. Now, as a young lawyer, I thought, gee, Judge, if I shot you through the arm, wouldn't it be serious? But it's not what the court said. So again, that doesn't mean that the person who shot him isn't guilty of any crime. It means he's not guilty of the more serious level of a crime. So the degree of injury can influence whether or not a person is guilty at all, or the degree of crime to which he is guilty for. And since more serious crimes have more serious punishment, that can be at least a partial defense. Another issue that comes up sometimes is mental health issues. Now, these can apply in any case, but if a person lacks sufficient mental capacity to understand what they did, they may have a mental health defense to the assault. In other words, somebody thinks that, oh, I was attacking the great pumpkin, and their brain is elsewhere. That could provide a defense. And a related issue is this person even competent to stand trial? In other words, are they so far gone mentally that they don't understand the proceedings and can't go to trial? But mental health can be a defense in an assault case. Another one is what I call the time or justice delayed. Years ago, when I was a prosecutor, I had a case where one fellow took the barrel of a gun and gouged a guy's eyeball out. I was very, very hot to put that guy in prison. The case got delayed and delayed. Court system is slow. Well, by the time the case finally came around, I had left the DA's office. There was a new prosecutor, and his original defense lawyer had passed away. There was a new defense lawyer, and the new prosecutor either couldn't find or didn't look very hard for the one-eyed man who had been the victim. The case got dismissed because of the time delay. So sometimes time is on your side. In fact, frequently, if you're accused of a crime, sometimes defense lawyers will intentionally drag their heels for just that reason, because you don't know what's going to happen. But so time can help. There are certain special defenses that apply in assault cases. For example, we have what I call a sock a cop law. If you punch a cop, it's a more serious crime than if somebody was to punch me. Cops have a privilege. Don't send me cards and letters. I know that a lot of people don't like police, and a lot of people may not like that they're given a privileged status in the law, but Alabama has done so. So if you knowingly are attacking a law enforcement officer or other privileged classes, that can be a more serious assault. Now, what if somebody's an off-duty police officer and you see them wrestling with your brother and you go over there and you're trying to defend your brother? That may be a defense if you didn't know the person was a police officer. It's not the crime that they're saying. Arguably, that would be your defense is, hey, I thought all I saw was some guy wrestling with my brother. Not, oh, it was a police officer in uniform and I knew I was interfering with the officer. There's other issues. Who's the victim in the crime? I had an assault case once where the victim, he goes up to my client's with his girlfriend. The victim pulls down his pants, shakes his privates at my guy's girlfriend, says, "What do you think I got to work with?" Well, my guy picks up a 2x4 that's laying there. Wham! That's what he thinks. He smacks the guy in the head. Charges assault. Did he assault him? Yes. Is there an argument that he was defending the girl? Perhaps. But when I say victim issues, the victim in this case was pretty unsavory. He was in prison for, surprise, a sexual offense at the time the case came up for trial. I said to the prosecutor, I'm looking forward to this because you're going to bring your guy with the little teardrop tattoos and all of his prison tats and his little orange jumpsuit to court, and I'm going to get to ask him all sorts of unpleasant questions. Prosecutor says, nah, we're not going to do it. And the case went away because the prosecutor he knew he had a very unsavory victim, and frankly, the prosecutor probably felt the guy kind of deserved it, even though technically you could have argued that my guy was guilty of the crime. So, what do you do if you're accused of assault? Well, obviously, you need the best lawyer you can get. If you'd like our help, give us a call. We're located here in North Alabama. Our phone number should be somewhere down here below. I hope you found this video to be educational and informative, and thank you for watching.